Good afternoon again, and thank you for joining today's webinar, Tips for Advocates with Clients Who Have Rent-to-Own Transactions. Today's presenter is Jennifer Schultz. Jennifer is a senior staff attorney with the Home Ownership and Consumer Rights Unit at Community Legal Services in Philadelphia, Pennsylvania. For over a decade, she has represented clients in federal, state, and bankruptcy court on issues relating to home ownership, predatory lending, and debt collection. She is a member of the National Association of Consumer Advocates. In addition to individual client representation, Ms. Schultz has been a guest lecturer at the University of Pennsylvania, a presenter for the National Association of Consumer Advocates and the National Association of Consumer Bankruptcy Advocates, and an instructor for many CLE courses. Ms. Schultz began her legal career as a law clerk to the Honorable A. Richard Caputo in the United States District Court for the Middle District of Pennsylvania. Ms. Schultz graduated cum laude from Cornell Law School in 2003, where she also served as Special Project Managing Editor for the Legal Information Institute and as an Associate Editor with the Journal of Law and Public Policy. Jennifer graduated magna cum laude from Boston University in 1999 with a Bachelor of Arts in Psychology. Thank you, everyone, for joining today, and thank you, Jennifer, and you may begin.
Well, thank you so much, Colleen. It's great to be back here doing another webinar on rent-to-own transactions. I think many of you may have attended the first one that I did back in July. And so we're going to go over some of that same information at the start, and then we're going to focus primarily today on what do you do when you have a client that you're helping who has these issues. So the first thing I'd like to do is get a quick idea of who I'm talking to today. So we have this survey. If everyone could just quickly fill that out and give me an idea of which sectors I'm chatting with so I can make sure to cover what we need to. So I think most people have gotten their responses in. We have a few housing counselors, a lot of people from nonprofit, a few people from government. So it's a really nice mix that we're going to be talking about today. So the first thing, just to recap, is what is a rent-to-own transaction? And this is the colloquial term that people will often use and understand, but the law does not actually recognize something called rent-to-own. And there seems to be a lot of different words that are used when people are being told about these transactions. But we're talking about this kind of collection of different ways that these deals can be set up. And the terms that are used are up here: rent to own, lease purchase, lease with option, contract for deed, and a lease with an escrow for purchase. So those are just some of the variations out there. And what's very interesting is I've actually started hearing that some of the sales pitches tell people, no, rent-to-own is bad. This isn't rent-to-own. This is lease with option. But I would suggest that many of those, I don't care what name is being used. If the deal is still structured the same way, it's still the kind of transaction that we're talking about. We'll get to that in the next slide about what they look like. Legally, these are called installment sales contracts. That's what Pennsylvania calls these. And when we struggle to understand precisely what these deals look like, because many times the documents that the clients will have do not necessarily match up with the terms of the deal. Sometimes people may grab a standard sales agreement for real estate, which is designed to be for a standard home purchase that has a brief contract period and then a settlement with full payment, and they try to squish the terms into different parts of that document. Or they may just take a form lease off the internet and then tack on an addendum. Or they may take one of these documents called a lease with option, and then they may actually, but they're trying to change the terms of how the option looks. Or again, just use the fill in the blanks to try and add in terms like, $25 a month applied towards purchase or something like that. And sometimes they don't even put it in the writings. They just have a lease, a standard lease. So there are different ways that they can try to structure these things. And it's important when you're interviewing clients to understand not just what the pieces of paper say. I always start first by asking the client, what is your understanding of this deal? And then I look to see, are there any written communications that reflect that? And then I look at what the documents say. So it's a little bit of a different process than a standard client interview. And just to give you an idea again about how do you understand when do you have one of these rent-to-own transactions, the items in red are the most crucial. So Pennsylvania law, they don't have this 100% defined, but what is clearly understood is if you have a monthly payment where a whole or part of that payment is applying to a purchase price, then certain laws are going to automatically connect to that transaction. And it's going to be treated like an installment sales contract for the purposes of Act 6. And it's also going to then push that transaction into requiring an ejectment rather than an eviction. And most people do not understand this. Most legal professionals do not understand these provisions. But I would say when you're trying to figure out, is this a rent-to-own deal or is this something else, that's the most key factor. Whether or not it says it in the paperwork, is the intention of the parties that a portion or the whole payment is going to get applied towards purchase price. So there are many different laws that start to get implicated in these kinds of transactions. Not all of them will be applicable in all instances. Again, I mentioned Act 6, and the triggering event for Act 6 is when you have a monthly purchase price with portions applying to a purchase price. So in those and when you have that, then Act 6 does become applicable, and Act 6 along with it incorporates the requirements of compliance with RESPA and TILA with the requirement of the Act 6 default notices and creates a right to cure. And again, this is where most sellers will fall flat in their compliance with the law. When they try to cancel the transaction when a problem develops, they don't know that they need to follow Act 6. This can be a very powerful tool for a consumer who's in a dispute because noncompliance with Act 6 is a jurisdictional defect, and it allows you to get the entire case kicked out of court. There's also Act 91. For those of you in the housing counselor realm, the Act 91 is the law that creates HEMAP, and HEMAP is designed to also be available to purchasers in rent-to-own transactions. A lot of people even at PHFA don't understand that, and there are a lot of issues about how you actually make that happen. But if the seller is required to send an Act 91 notice, then HEMAP does apply. And I say if because Act 91 is not going to be applicable to a small-time seller, a person who's in a solo transaction. They have to be kind of more of a repeat player in the realm of doing these contracts in order for Act 91 to become applicable. There also are laws that regulate mortgage lending and licensing requirements, and it's possible that people who are doing these transactions may be violating those rules as well. So just very quickly, some of the other laws that can be applicable if you're in Philadelphia or Pittsburgh, which are the counties of the first and second class. There's a special law, the installment land contract law, that has additional rules about how the payments are supposed to be applied and the methods for cancellation and what to do in terms of default. So if you're practicing in those areas as an attorney and you encounter one of these, don't forget to look at that law as well. I know in some other parts of the state there are a lot of mobile homes that may have these rent-to-own transactions as part of them. The Manufactured Home Community Rights Act does not necessarily speak to this issue directly, but it will provide some baseline requirements for the way that that relationship is supposed to exist. There are also rules about how realtors are supposed to behave. And the reason I mention that is sometimes what you see in these transactions is that there was actually a person who was brokering the transaction who was connecting a novice or unknowing seller with a buyer, and it really may be that person brokering the deal who may actually be kind of the bad actor in the thing. And real people who are brokering transactions, if they're taking a commission or taking a service fee for connecting people, they need to be licensed to do that. And there are a series of rules and regulations that realtors need to comply with. So if they're not licensed, that's a problem. Or if they are licensed but they're not making sure these deals follow all of the steps of the transaction, that's also a problem. And then generally we have the catch-all laws of the unfair trade practices and consumer protection law. So you can look for issues there regarding warranty of habitability. If the transaction looks more like the person is a tenant, there could be problems there with habitability that could create violations, plus also the general catch-all provision where if the deal is just structured poorly or the practices of the of the sellers in the transactions are onerous, you may be able to get them for their violations. Also the Fair Credit Extension Uniformity Act, that applies to creditors and their behaviors in collection. And sometimes when these deals go sour, you may start to hear stories about onerous practices or harassing practices being done by the sellers trying to get people to leave or to pay. And if they go too far out of bounds, they may start violating the Fair Credit Extension Uniformity Act. And that's a state law. It tracks a lot of the FDCPA, but it's applicable to creditors as well as to debt collectors. So original creditors can be held accountable under that rule. And then there's also kind of the basic judicial principles of unjust enrichment. This can become very useful for individuals who have spent a lot of money repairing or improving a property with the expectation that they would be owning it. And then if the deal falls through or there's another problem that develops, they're seeking compensation. Potentially unjust enrichment could be a mechanism for that. And just very quickly, I want to flag this. Some of the problems that can develop here also are issues where a dispute with a third party arises and your clients who are in possession of the property, that creates notice. Even if they do not have a recorded deed or a recorded contract, their possession and control of the property is legal notice to the world. And there's pretty solid case law on that point at the state level. And also, a lot of people think that you need to have a written contract for land in order for it to be valid. That principle is called the statute of frauds. Generally that is true, but there are exceptions. And the exceptions are they have to meet 2 of 3 tests. They need to have full or partial payment. The buyer has to have possession, and the buyer has to have made repairs or improvements to the property. Typically these transactions, all 3 of those prongs will be met. And so a lot of the document issues that can arise with these issues, you're able to overcome those arguments in a court setting because we have these backstops through our common law principles. So hopefully what's clear by this point is that rent-to-own transactions really are not good for buyers. I actually argue they're not good for either side, but for our purposes today I'm focusing on the buyer. A lot of different problems can develop in these transactions. Some of it can be well-meaning sellers who don't follow through or who think they're following through but don't fully understand. I spend a good deal of time trying to get purchasers' deeds because they finished buying the house 20, 30 years ago and no one ever thought to finish the paperwork, which creates massive problems now because they have to hunt down the owners to finish up the paperwork, or the sellers rather. The other problems that can develop are well-meaning sellers who don't comply with the law. We talked a little about Act 6. They may just not understand what the rules of fair play are, and they may have been told this is a fair deal, but they don't understand what it means to enter these transactions and what their duties are. And so they may, or they could be getting very bad advice. A lot of people who seek out advice, a lot of sellers who seek out advice tend to find themselves talking to landlord-tenant attorneys who understand landlord-tenant law, but they may know little or nothing about purchase law. and laws governing sales of property. And they may not understand all of the additional regulations and laws that are applicable to these cases. And that's some of what we talked about earlier, all of the different laws that we were just discussing. Then you get into the other issues. These transactions, you can have sellers who are predatory, who are creating transactions that are not evenly meted out in terms of responsibilities, that are heads I win, tails you lose transactions, and it can create very big problems for successfully completing the deal, particularly when you have inflated purchase prices built into these, or inflated interest rates. So Pennsylvania has, under Act 6, a general interest rate cap of 6%. Well, it's a floating interest rate. 6%. So for houses it's a floating rate, which can just be looked up on a chart. And people may be, picking a higher rate, not understanding that you're not allowed to do that, or no one's ever called them on it. And then they're predatory sellers where they may intend to finish the deal if people get through the deal. And then there are the scammers where they are doing built-to-sale transactions where their business model is really that this person is not going to finish buying the house. We have a very bad seller, bad actor right now, who's operating across the country, and we know that they're in Pennsylvania. They're management companies called Vision Property Management, and their transactions, their whole business model is that they put people into dilapidated, uninhabitable properties. They tell the people that they are responsible for all repairs and they are responsible for bringing the house up to code. And there is an option price that's built into the transaction, but it is a grossly inflated price that they would never actually be able to get on the open market. People go through the deal for several years and invest typically 5 figures or more trying to make the property habitable. And then the deal crumbles and they do a quick ejectment action and remove people, and then they immediately turn around and rent the property again in one of these transactions to another person. And so their whole business model is they're getting the tenants to fix up the properties, and then as soon as the tenants fall behind on the inflated rent, they kick them out. The other issue that can develop here is not a problem between the buyer and the seller necessarily, but a third party. And we're going to talk more about what those problems can look like. It's extremely difficult for a person who's buying under one of these deals to solve problems with third parties who may be involved. And we'll talk about that later. So what are you supposed to do if you have somebody come in with these deals? So there are different points. I spent a lot of time and many years now representing people in rent-to-own. And I've learned a few things about what you do when one of these comes into your office. And I think that there are 3 or 4 different case postures. And so the first thing I recommend is you figure out which case posture you are looking at. And it's primarily going to be about how, where are you in terms of the term of the deal. So if you're at the very beginning, client has not entered the deal yet. They walk in and they say, I'm thinking about doing this. Or they walk in and they say, I've got this contract to sign. Let me tell you about this great deal I just found. So if you get somebody before they're in the contract, there is only one correct answer. Do not enter the deal. It is never a good idea to do these deals. Even when you have the most well-meaning, the most well-intentioned seller on the other side, even when the terms of the deal are fair in terms of the compensation and the structure of the deal, it is still not the kind of transaction that people should enter into. Instead, so I'll talk about what you do instead. There's one exception to this. So I mentioned at the beginning that some of these rent-to-own deals are being they're being labeled leases with options. So that's actually a misnomer when it's being used in a rent-to-own deal. Leases with options have very specific legal meanings that are being contorted in these rent-to-own deals. But a lease with an option that's a legitimate lease with option transaction can be a valid transaction and can potentially be an acceptable transaction to enter into. So let's talk for a moment about when somebody truly has a lease with option versus when somebody has one of these rent-to-own deals that has the lease with option label slapped on it. So a true lease with option that it would be acceptable and okay for a client to enter into. First, there should be low or no consideration for the option. So in this sense, consideration is the legal term, meaning what do they have to pay to get this option. Some of these deals are built with a consideration that's multiple thousands of dollars. I've seen $1,000, I've seen $5,000, I've seen $10,000. If somebody's paying a consideration to get an option, that is non-refundable money, unless it specifically says otherwise in the deal. But typically, they are non-refundable amounts. So if somebody's paying $10,000 just to have the option, what happens when they don't buy the house? They've thrown that money away. I would suggest that is never okay for somebody to be paying that much money up front in a non-refundable mechanism. But if they're getting an option that's built into a standard lease and they're paying nothing, or maybe they're paying $500 or maybe $1,000, and they understand that it's non-refundable and they're okay with that, that might be all right. I would say anything over $1,000, they should just not even be going there. The next requirement that I cannot stress enough is that in a legitimate lease with option, when the person is leasing, before they exercise the option, they must be behaving like a true tenant. And there shouldn't be any provisions that are pushing repair obligations onto the tenant. The landlord is supposed to perform repairs. Taxes and insurance for the property, those things are supposed to be paid by the landlord in the traditional landlord-tenant relationship. If you have a lease with option, the person is still a tenant when they're leasing, and the landlord should still be maintaining all of those traditional landlord obligations. So that's that big hallmark to know whether this is a true lease with option where the person is a tenant first and then has the option to become a buyer versus when they're trying to mush together one of these installment sales contracts. Also, you should look at, is the person being charged more than a market rate for the rent? So essentially, are they trying to capture purchase price through the monthly rental payments? If they're paying the same amount that anyone else would ordinarily pay for this rental, and they're paying that as their rental, that's okay. But if their rent has been doubled because it's a lease with option, that's a giant red flag. That should not be going on. Similarly, and I cannot emphasize this enough, the option price should reflect a true market valuation for the house. Many, many times with these leases with options, the option price is some random number that the seller landlord has come up with. And when you ask the person, well, why did you come up with this price? They don't have any answer other than, well, that's what the price was. And the reason this matters so much is the idea behind a lease with option is that when the person's ready to buy, then they just buy the house. And typically they're supposed to tender full payment. They're not going to convert to an installment sales contract. They're going to tender payment. So if you have an overvalued property for your option price, the person will not be capable of getting a mortgage to complete that option. That's a hallmark of a built-to-sale transaction or predatory transaction. They're happy to take somebody's money if they have it, but if they can't be able to enter the regular purchase market and complete the transaction, the likelihood that it will actually get to completion is very small. And lastly, in terms of what a legitimate lease with option is, option means optional. The person, the buyer, the tenant, is not supposed to be obligated to purchase the property. They have the choice, the option to purchase the property if they elect to do so, without any penalty if they elect to walk away. And so looking, when you're evaluating, is this really a legitimate lease with option, the person should be treated as a tenant, and that tenant relationship should be a fair and properly valued tenant relationship. And then if the tenant chooses to buy the house, they should be able to complete that transaction like any other market transaction. So but other than that, they should never, ever, ever do a rent-to-own deal. It doesn't matter what the name at the top of the contract is. Are there any questions about that part? Because I know there's a lot going on in that part we just talked about. Okay, so I don't think anyone has any questions. I'll keep going on, but if you do have questions, please feel free to write them in the questions section on your webinar screen. So what do you do with somebody? They've walked in, they say, I want to sign this, and you tell them, no, don't you dare. First of all, they are not going to want to listen to your advice. I will warn you right now. People want to be homeowners, and this very nice person who has told them about this great way to buy a house is showing them what they think is the path to their goal. And so it's very hard to effectively convince a person this is not the right way. And what's useful to work with them on is what is their alternative. A lot of people get into these deals because of housing insecurity and because they don't think that they can engage in the traditional lending marketplace. So I would suggest any person who is trying to buy a house should be working to qualify for a traditional mortgage. And maybe that's not something they'll be able to do instantly, but beginning that process of thinking about the person as a pre-purchase transaction, or working on credit repair and credit building so that they're on a path that will allow them to access the traditional mortgage market is one of the best things that you can do with somebody who's looking at these deals. Show them there's a better path where they will be more protected, that is a more secure way of actually becoming a homeowner. Alternatively, if you have one of these legitimate sellers who wants to be honest and wants to do a fair deal, an alternative that can be arranged is called a seller financed mortgage. And so this transaction is pretty simple. The seller will deed the house to the buyer, and then the buyer simultaneously executes a mortgage back to the seller. So the seller becomes the mortgage company. So there's no cash that changes hands, or there might be like a down payment that changes hands, but basically it's just, I promise I'm going to pay you, and I'm going to pay you, the full total price, and it's going to be paid in these installments. The difference is that the buyer gets the deed on the front end. This is beneficial to both parties because all the liability of that property is going to be in the hands of the buyer. So the seller is not going to be on the hook for unpaid taxes on the house, or if somebody has a slip and fall in the house. Those liabilities are only going to be borne by the buyer, who's now the owner. And that person will be the record owner. And the other thing is the seller still has a remedy to enforce the deal. So if the buyer doesn't complete the payments, the seller can foreclose. Now, for those of us who practice in the foreclosure market, you may know that foreclosure can take a long time in Pennsylvania, and it can be costly, and you have to go through a sheriff sale. But I would suggest a person who is in doing a sale through a rent-to-own transaction, they have to go through an ejectment. So again, if they're a legitimate person, business person who intends on complying with the law, they don't get to go to landlord-tenant court and remove a person in 45 days. Ejectments in Philadelphia are taking 12 to 18 months at this point, and it can take even longer if it's a disputed ejectment process. So the difference, the time delay is not as significant as one may think. What I would say for anytime we're talking about a deed or a seller-financed mortgage, you want to use a settlement company or an attorney, or perhaps both. These are not things where somebody should be pulling a document off the Internet, no matter how great the Internet site seems to be. These are complex transactions. There are a lot of different moving parts to it, and it is crucial that all of the parts are done correctly so that so the buyer is protected effectively. And the settlement company, transactionally they can cost about $1,000, maybe less, for their services, and that's kind of built into like document preparation fees and courier services and notary services. That's where they get their money. It is worth every penny, and so I strongly recommend that you really educate people about making sure that they do it the right way. They don't try and do any shortcuts on that step. And I still don't think we have any questions, so I'll keep going. Okay. So we've talked about, this last slide we were talking about what to do if someone comes in before they sign the deal. All right, so the next step is, what if somebody walks in and they've just signed the deal? Maybe they're 6 months into the deal. Maybe they just signed it the day before. So it's a slightly different situation because they're in a contract. They may already be in the property. They probably have some money already laid out, either in the payments to the seller or improvements to the property or both. So the first thing I would say is, if they're still early on, if there is a problem, they should get out of the deal. Again, there are predatory transactions out there. Some of these people may be coming in talking about severe habitability issues, and they should not be suffering those things. They should not be living in a house that has collapsing walls or collapsing roofs or windows that don't close. These things, those problems are not fixable, because if somebody is selling a house in that situation, they are not trying to be on the responsible seller and the responsible landlord. They're trying to get rid of their problem and make it your client's problem instead. And I would suggest that's not somebody they should be doing business with. The other thing is, clients may say, well, I'm already at $2,000 into this place. I really don't want to, I'm trying to buy it. But typically when you look at these deals, they still have a long way to go. They may, they're often like 5, 7, 10-year deals, maybe longer. There's a long way to go before success. And if they're already in your office with a problem, it is going to be an extremely long, extremely hard path, which may not result in a deed at the end. So if they just have a little bit on the line, getting out is still the better option. I strongly recommend that. And the other thing to look at, even if this isn't predatory, even if there isn't a problem, is the client really in a position that they're going to be able to get to the end of this deal? Again, if it's an option purchase, they may need to tender $15,000 or $20,000 at the end, or possibly much more. I've seen much higher prices as well. If they're not able to finish the deal, then why stay in it and continue to put more money into a transaction if they're not going to get the result that they want at the end? The other issue that comes up is we don't know what problems are out there. We may think everything is okay, the client says everything's great, but we don't know. All of these problems are not identifiable on the front end, and the client is very vulnerable the entire time they're in the transaction. There could be ownership issues that may not even be identified. You don't know if the person has clean title or without any disputes of ownership. There could be liens that are not easily identifiable. In Pennsylvania, any monetary judgments in the same county where the property is are automatic liens against any real property in that county. So doing just a look at the recorder of deeds does not give you the full picture of liens that may be out there. You're not going to see IRS liens in that way, and you're not going to see judgments. There are additional places that need to be searched to get a full picture of what liens are in existence. The other thing you need to remember is, just because there's no lien today, there could be a lien that gets put on there tomorrow. And so even though earlier we talked about how possession does protect the the purchaser in some ways, the truth is the buyer needs a recorded interest. They need it to protect the seller from draining the equity from the property or selling the house to somebody else. They need it to prevent a lien from getting placed against the owner of the property. So if there's an IRS debt that develops 5 years into the deal, or if they get sued for some other issue that has nothing to do with the house and there's a judgment that gets placed, all of those things can then potentially impact the ownership of that house. And perhaps your client can defend against those issues, but that is not a fight you want to be in. What I would recommend is that a person who's in one of these deals, they don't understand how much is at stake that could blow up this deal that's completely out of their control. I'm seeing a note here from one of the questions. Somebody's saying that he's seen contracts where in the event of a default, it automatically changes from a purchase transaction to a lease. And that was from Mr. Zimmerman. So yes, I have seen those provisions in documents. I would suggest that Act 6 specifically prohibits that, and that is a statewide applicable rule. Act 6 requires a right to cure. So any instant default provision that instantly causes the loss of all of your rights, I believe is violative of the right to cure. In addition, you cannot default a person until you've sent them the Act 6. You can't accelerate the debt, or you can't lose their rights. So they have to, I would suggest that until a properly written Act 6 notice is sent to a person, they are still not able to claim any default provisions. The other nice thing is Act 6, the rights and protections in Act 6 are non-waivable. So they are not going to be able to say, hey, it doesn't matter what Act 6 says. This person agreed to this other alternative way of working. Act 6 is non-waivable. So they're not going. So any portion of the contract that is contrary to Act 6 is not supposed to be legally enforceable. I would suggest you're going to have to go through the process of educating the bench and opposing counsel about any of those issues as you encounter them. That's often where a lot of the advocacy winds up in these cases. It's about making sure everybody involved understands the applicable rules, and they will try all of these creative arguments because they don't understand the case law. And the good news is that Act 6 is a pretty fairly vibrant set of case law. I have some of those citations, but we also have a lot more. But they'll still raise arguments that are not necessarily applicable that have already been shot down, and you're going to have to remind the court again, no, see, this has already been decided. Here are the 6 cases that have decided this. It's a common problem that we deal with in litigating these cases. So thank you for that question, because that's an important issue. All right. So getting back to somebody who's in one of these deals, and they need to get out of it. They're having problems. It's early on. They're not that far in financially. Once they decide that they're going to walk away, once they've figured that out, that it's the right way to go, they have to make sure they do it correctly. Because they have signed a contract, if they simply stop making payments, they could find themselves dragged into court by the seller. They could also, and it's very common that sellers will try to go to landlord-tenant court, even though they should not be there. If you're there, now you have to deal with that problem and convince the judge you're in front of that this is the wrong forum. So they need to think very strategically about when do they discontinue payments. How do they do that in a way that prevents them from being sued for breach of contracts or damages? I would suggest they also need to have their relocation plan in place. These things need to be done with thought, and I would suggest in consultation with an attorney. Some of these contracts may have cancellation provisions in them, and it's just a matter of following those cancellation provisions. The installment land contract law that's applicable in Philadelphia and Pittsburgh has very specific provisions on how you're supposed to unwind one of these transactions. So it's not as simple as, okay, I'm done, I'm just going to stop paying. there needs to be a clear plan that includes a relocation plan as part of it. And sometimes a person may say, well, I need 6 months to be ready to move, and they may want to pay a few months to buy them the time for that relocation, if that makes sense. Other times they might say, you know what, I've already put $5,000 into repairs. I'm just going to stay here until I recoup that money. I'm not going to pay any rent. So figuring that out with an attorney is really crucial. As an alternative, as a last alternative, if there's nothing predatory about the transaction, the person's happy with the deal, they're happy with the seller, it appears to be a very good faith deal, I would still suggest, because of the risks that are out there with liens and with having recorded interest, making sure the buyer is protected, it still makes sense to try and transition the deal from a contract over to a seller-financed mortgage. That's always the ideal result, is always your client has a deed before they finish paying. It's better because their rights will be recorded and they are protected, and the seller still has the ability to collect through the foreclosure process. All right. Any other questions about this slide and this status in a case? Okay. All right. So I'm going to jump ahead for a moment. What if somebody comes in at the end of the deal? All right. Get a deed. At this point, the most crucial thing is to get a deed. All right. Not all deeds are created equal. Quit claims are bad. So the quit claim deed it lacks any promise that they're transferring anything at all. It's the seller saying, I don't know what I have, but whatever I have, it's yours now. And anytime there is a quit claim deed in the chain of title, it creates a cloud on the title, which means that your client will have massive impairments to being able to mortgage the property or sell the property in a standard transaction. It basically makes the title of the house uninsurable. It used to be that the title insurance companies are more relaxed about that. I'm now reached a point where a quit claim is it's just never going to be acceptable, because even if it's 15 or 20 years in the past, the title insurance companies are refusing to insure these houses, and they're saying, go do a quiet title action. Go do a lawsuit to clean that up before we insure your title. Okay, so we're talking about getting a deed. Part of the issues you need to sort out in the deed process: who is going to pay transfer taxes and recording fees? In a standard real estate transaction, the standard contract outlines all of those things. These rent-to-own transactions, nobody thinks about any of this stuff. So you get to the end of the deal, your client walks in and says, hey, I'm done buying my house, I just need the paperwork. And now you have to bring up like 15 issues they haven't thought about. Yet another reason these deals are not deals you ever want your client to get into if you could talk to them on the front end. So you have to sort out the transfer taxes and recording fees, how much they're going to be, who's going to pay them, and P.S. So for transfer taxes, you have to put in the full purchase price that the person paid over the term of the contract, not just $1. You can't. That's tax fraud. So outstanding liens have to be addressed as well. Again, does the seller have some judgment lien that's now attached to the house that the buyer had no idea about? Is that going to get cleared up in the process? Which is why title insurance is so crucial. If your client goes through a settlement company and gets title insurance, the title insurance company will do a title search and will identify any of those issues that may be out there. They will also make sure that the deed is at least a special warranty deed, not a quit claim. And so you don't have to know all of these details. By going through the settlement company and buying title insurance, these things will get taken care of and your client will be protected. And that's what is so crucial. And the next part I do suggest you could also use an attorney. In Pennsylvania, you can have an attorney serve the function of a settlement company. But I would suggest that a settlement company is probably less expensive and easier. Occasionally, a title company or occasionally you may wind up with a problem that cannot be resolved, and it becomes a situation where the house may not be insurable. I would suggest you still want to get the deed. If you have a cooperative seller who is willing to sign the deed, that is always going to be preferred to not having the deed. Whenever possible, they should go through the full closing process with the title insurance and everything else. But if you run and hit a snag, still get the deed, sort out the mess later. All right, let's see. The other things you should be talking about if someone walks in and says, hey, I'm done. How sure are they that they're really done? Do they have receipts? Have they read their contract? Sometimes people don't understand that they were supposed to be paying property taxes that whole time, and there might be tax delinquencies that they now need to cover that they didn't understand. A great way to deal with this also is to send a letter to the seller asking them to confirm the status and the accounting in writing. Act 6 helps us out here. They have a responsibility to do writing. So sometimes you may, in that process where you send that letter, now there may be issues about who is responsible for paying what. I have a couple of those cases right now. And so you may have to do some negotiations, and sometimes your client's not going to be in the right on all of these things, and it may mean that you have to rework the deal in a new way so that you can actually get to completion. I've had these issues come up in almost every different permutation. One of the things is, perhaps the seller in the contract was supposed to pay the property taxes, and they didn't. And maybe halfway through the deal, the buyer started paying them to prevent a sheriff's sale. Well, now you need to have some kind of an offset on the purchase price to address that. Under contract law, that's a breach of contract loss. All of those things can now cause disputes that need negotiation, and sometimes, if it's a small dollar amount relative to the full contract, it might make sense just to accept something that's a little less than 100% right as a way to get to the deed and to closing the deal finally. Lastly, when you don't have a resolution, when you can't negotiate to a resolution, when you have an uncooperative seller or you have a missing seller, the only way to fix that is a quiet title action. That's a lawsuit. It is not a lawsuit that a layperson should undertake on their own. It is a very complicated pleading. You have proof, and then making sure that the court orders are done correctly so that you have full, clean title. It's very specific pleadings and wordings need to be done to fully complete the quiet title action. Sometimes people do them, but they don't get the right paperwork, so it was a worthless lawsuit. So absolutely, they need an attorney. They need an attorney who understands this area of the law if they're going to fix that. So I see a couple of questions. We're going to get to those right now. Maureen asks, do you have suggestions for a nonprofit working with FTHBs who would like to offer lease to purchase agreement? Maureen, I'm sorry, I don't know what an FTHB is. Could you please provide the explanation of that so I can answer the question? And then Sarah asks, an issue I keep encountering is that very low income clients have great difficulty in finding free legal assistance. Being a social service provider, I don't have adequate knowledge to counsel a client or even know what to look for. Okay, so I'm going to jump ahead a few slides to answer Sarah's question. So Sarah, what I would say first is Pennsylvania Legal Aid Network. They are the statewide organization, and on their website they have the links and the information to access the local legal aid organization that services your geographic area. And there is a legal service that is servicing every area in Pennsylvania. So wherever you are, there should be somebody your client should be able to talk to. I think the problem your clients are encountering is very often they're told that legal services doesn't do that kind of case. I think that is changing. The reason that I'm talking with all of you today is because the legal services around Pennsylvania have realized this is becoming more and more of a problem. We're seeing more of these cases, and we need to know what to do with them, and we need to build up our resources to represent these people. So I'm actually being funded at the state level to do this kind of education for legal services attorneys, and I am available as a resource for them across the state. So if an attorney lands one of these cases, I'm often getting the calls and the emails and giving them the advice on how to handle these cases. You know, it can still be difficult because not every organization is prioritizing these cases. They can be very complex and very time-consuming to address these cases, particularly when the client is in a situation that may not be solvable easily. And so not every case is going to get representation, but I would say keep trying with legal services. In addition, every county bar association has a lawyer referral service. And for a nominal fee, a person can get a half-an-hour consultation with a private attorney. And so that is, if you connect with your local bar association, they will have their lawyer referral and information service number. The fee is typically like $30, $35 for that half hour. Yes, after that, things become more expensive, and that can be a barrier to a person completing litigation in these areas. The nice thing is, if they're at the end of the deal and they need to litigate a quiet title, they have time to save up the money. If they don't need to pay rent anymore, they can save up until they're able to then go and move forward with the case. So, you know, the other thing is if they're dealing with really onerous practices like unfair trade practices or debt collection violations, you may find attorneys who will take those cases without requiring retainers on the front end. Okay. Going back to Maureen's question. So there are nonprofits working with first-time home buyers who like to offer lease-to-purchase agreements. Maureen, I've got to tell you, I haven't actually seen that. The only home buyer transactions that I've seen involving lease to purchase is the VA, the Veterans Association. They had a program that was an installment sales contract program. Quite frankly, they still develop some of the same problems that we've been talking about today. I've represented several people in those deals over the years. When you have an issue with payment history or amounts due, it can get just as messy and the litigation can be just as protracted in those areas. So I would be curious to talk with you further and to understand the nonprofits that are doing these lease to purchases. I'm not sure if maybe they're doing something that's a more like a true lease with option, where the person is truly a tenant, and then at some later point they can purchase the property. Again, as I talked about, those are legitimate transactions. But anything other than that, I really start to question why they're structuring the deal that way. It's just not a good deal for the people who are buying. There are too many problems that can develop, even among well-meaning parties. So please, I would love to talk with you more, Maureen, and understand who's doing those deals. In the last few minutes that I have, I do apologize. There's a few things we haven't talked about, which is when you're in the middle of the deal. If you have a client who's got a 15-year lease, rent to own, and they walk in on year 8, it's going to be hard. I would suggest you're going to need an attorney. If they have a problem and they're that far into the deal but they're nowhere near done, those cases are very, very difficult to find a resolution for. For case evaluation, there are a lot of different questions you need to ask. You need to understand, are they managing the payments? Have they been on time and they've been consistent? Do they have a spotty payment history? Are there problems with the condition of the property? Is it habitable? If it's not habitable, that can be a serious issue when they're in the middle of the deal. Exactly how far into this deal are they, both in terms of time in the house, in terms of the length of the contract, but also how much have they invested into the property? Because sometimes they might only be 6 months into the deal, but they may have spent $10,000 fixing up the house. And I would suggest that's going to be a complicated problem, because that's not someone who's going to be able to just walk away. They're too far into the deal. They're not going to walk away without getting compensation. They're not going to get compensation from the other side. and figuring out what do we do to get this person treated fairly can be very difficult. And it's very fact-specific to the individual case. Again, I would say as a starting point, it's always a good idea, well, not always, but if there's an issue and you're trying to sort out these cases, asking the seller to confirm the status of the contract and an accounting under the contract in writing. So, what does the seller think? Your client says that they're current on payments. Does the seller think that? A lot of times those two things don't line up exactly. Don't forget to ask the client why they came in for help. I think sometimes they bury the lead and 45 minutes into the interview they pull out the sheriff's sale notice. If that's going on, you need to understand that. You need to make sure you're getting all the facts of the case. Okay? Make sure you get the contract, plural contracts. Okay? You would be amazed how many times there are multiple documents that have been executed at different times or perhaps at the same time. Maybe they did a contract for sale and then they executed a lease so the person could get utilities on. Or maybe they had one contract and then later their problem is developed and so they did a new contract that rewrote all the terms. Make sure you have all the paperwork that could possibly pop up. Make sure your client collects their receipts and their proofs of payments. You want to start having your client create a record of their repairs and their improvements that they've done. I have a little chart that I send the clients home with. I tell them, walk around your house, and every time you remember something you did, write it down on there. See if you have a receipt for that. But even if you don't have a receipt for that, give me the estimate of what you spent on that. Make sure you're gathering and maintaining all of the correspondence that may have happened, mail, email, and text messaging. A lot of these deals, these are perhaps on both sides, are not very sophisticated parties, and they may be text messaging as the primary or maybe even the sole method of communication. I've had contracts that have been done basically as an email that was sent outlining the terms of the deal. And make sure you give the client a chance to give you the full story. If they have a 7 or 8 or 10-year time in this house, there's a lot of story there. And it may take a couple of meetings to kind of get that full picture to understand everything. And lastly, don't forget to ask the client what they want. Most of the time, if they're in the middle of the deal and they've got a lot of money into the house, the client is going to want that deed. They are not leaving. They are emotionally and financially invested in the house, and they're going to want a deed. But not always. Sometimes clients are kind of done with it. They've been limping along and struggling and living in a house that was subpar, and they just want out. So it's important that you understand what your client's goals are, so that you can structure a strategy that's consistent with what their needs are. And again, you'll definitely need an attorney if you're in this like middle area. If the clients come to you at that point, it's because there's a problem, and those problems do not get solved outside of litigation. And again, even if they're deeply into the deal, if it's a really predatory deal, there may still be issues about whether or not they should continue to go forward. But now the consequences of discontinuing the transaction can be much more severe. And again, you need to make sure that those cancellations are done correctly if that's where they're going. And still, I would suggest that it's important to get the client towards a traditional mortgage. More frequently, if the client wants to finish the deal, if they can qualify for a mortgage, they can buy out the rest of that contract. And so it might mean we're going to spend the next year or 2 years getting your credit in order and getting you ready to get a mortgage, but then you're going to own this house. And sometimes that is, and I would suggest that is the most successful solution when you're dealing with somebody in the middle of a long-term transaction. And again, if you have a seller who is good faith, you could potentially still transfer it to a seller-financed mortgage. We are out of time. I do see it's 1 o'clock. Clashes with third parties can come in many different varieties, and I would suggest almost any of these are going to either require a client to pay money or an attorney or both. If there's a property tax problem, the solution is your client needs to pay the property taxes. Because they may then have to offset that against what's owed under the contract, but if they don't fix that tax problem, they're going to lose the house. Insurance problems are often not resolvable. Insurance company, homeowners insurance will not typically write to a non-deed holder. And then all of these other things that can come up. Accessing low-income programs typically are not going to be available unless you have a deed. These things are very, very messy situations, and many times may not be solvable. Also, with the idea that your client may need to pay money, some of these like mortgages, they might not know about it until the amounts of money are very large to solve the problem, and your client doesn't have those lump sums available. Bankruptcy, Chapter 13 bankruptcy can oftentimes be a solution. I've used Chapter 13 bankruptcies to fix these third-party disputes because the third parties will not acknowledge the buyer directly, but bankruptcy courts will. And often that can be the most friendly forum to go to for solutions. And it allows them to impose a repayment agreement on an uncooperative third party. And again, here are some resources. Hopefully you understand having access to attorneys, settlement companies when it's time to do the deeds. Housing counselors are a crucial part of this, especially to get people ready to qualify for mortgages. Some local programs can potentially work with rent-to-own people, and spending time educating the people who work in those programs. They don't necessarily understand rent-to-own. They say, and letting them know that this problem is out there and these people need help just as much as tenants and just as much as owners, and building new programs that will allow them to have access to that. And for folks who are interested in more information, there are some great articles here that talk about the history of rent-to-own, the emerging problem and its reemergence around the country. And Matt Goldstein at the New York Times did this great series on vision property management and their predatory practices. So I see there are a few more questions. I'll stay on to answer those, but I did want to just let everybody go since we are at the hour. And I thank you so much for your time. So B asks what attorneys are aware and well-versed and truly knowledgeable of Act 6 instead of just landlord-tenant representation in front of a judge. So B, the simple answer is people who do mortgage foreclosure defense. They are people who know Act 6. If anyone who practices mortgage foreclosure defense in Pennsylvania should know that law. And I would say, so looking at someone who's a home ownership attorney, the private bar may not be as well versed in it. That's really where connecting with legal services can be helpful. They've actually done a lot of hiring. So they've really staffed up home ownership for all the legal services around the state. And all of those attorneys are getting trained on Act 6. And I would suggest anybody who's kind of like rent to own, I don't know what to do, give them my name. I am available to be a resource to any attorney, whether they're a private attorney or a legal services attorney. I'm happy to share my briefing. At this point, I've got it as a standard 3 paragraphs that I cut and paste into emails almost on a daily basis to somebody who needs it for court. And my goal is to have people know this law and know how to protect people in these transactions. And I'm happy to assist any colleagues out there who are dealing with this. Okay, Matthew Rich, he writes, what circumstance must be present to require the seller to undertake the foreclosure process as opposed to merely filing an ejectment? So Matthew, that's actually a good question. Foreclosures are specifically only supposed to be when there is a mortgage. So if a person who has an installment sales contract, they will always go through the ejectment process in the Court of Common Pleas, not the foreclosure process. Now remember, ejectment is different from eviction. Eviction is landlord-tenant court before the magisterial district judges. It's designed to be streamlined, and it's intended for landlord-tenant relationships. Ejectment is the Court of Common Pleas, and it's a slower process, and it is for any relationship where an owner of a property wants to remove somebody from the property who they allege does not have a right to be in the property. So traditionally it was also landlord-tenants, but they have eviction now. They much prefer eviction. But it's also used for these kinds of transactions where what you say is, we had this contract, the buyer breached the contract and I've complied with Act 6, so now this person needs to be removed from my property. And then what can happen in the context of ejectment is the possessor defendant will come in and raise their defenses, and that's where you would litigate the disputes. And they can also do counterclaims in the ejectment process, so they can raise issues like unjust enrichment, if they violated the warranty of habitability, if there are other contract disputes in terms of sums and accounting disputes, and if they have if the buyer's position in that ejectment case is, hey, not only did I not breach the contract, but I'm done and you owe me a deed, then they can actually counterclaim with the quiet title right inside that ejectment case. So ejectment is where you want to be. Foreclosure is not set up to deal with these issues, and it should not properly be brought into foreclosure unless they did a seller-financed mortgage. That would be when it would be proper to be in foreclosure. Okay, so Sarah asks, yes, can we get a PowerPoint? And the PowerPoint will be sent around next week. And Matthew is asking, Act 6 applies to installment sales contracts. Yes, absolutely, positively yes. So it's not clear if you just read the statute. You have to go and read the regulations that go with the statute. And in those regulations, I'll actually read it. Let me pull up the citation that I use. Sorry. Okay. So the regulations, which are 10 PA Code Section 7.2, define a residential mortgage to include, quote, an installment land contract, or lease purchase agreement. It shall also include any similar document if it is a lease of real property where the lessee pays or agrees to pay as compensation a sum substantially equivalent to or in excess of the aggregate value of the property, and it is agreed the lessee will become the owner of the real property upon full compliance with the terms of the agreement. And that's also reaffirmed in Anderson Contracting v. Daugherty, which is the Pennsylvania Supreme Court in 1979. And I believe I have that Anderson citation in the slides. So when you look at the full law that applies to Act 6, it is very clearly supposed to include these things. The problem is that a lot of practitioners don't know that, and that's why we're talking today. I think I've answered all the questions. If there's anything else out there, I'll be glad to take those questions now.
Great. Thank you, Jennifer, so much for your presentation, and thank you everyone for joining. And since there's no more questions, we're going to end today's webinar. And thank you again, Jennifer. And I just wanted to make one brief announcement. The Housing Alliance has our 2018 conference at the end of October, and we're actually currently taking workshop proposals for our conference, and they're due at midnight on Monday, April 2nd. So thank you again, Jennifer, and thank you everyone for getting on today's webinar, and have a great weekend.